Welcome everyone to today's webinar on Protected Beliefs under the UK Equality Act 2010. So today we're going to explore how UK law defines and protects different types of beliefs and characteristics, and then how organisations can manage the potential for conflict between these beliefs and characteristics. And one of the most challenging areas is balancing the rights of employees who hold gender critical beliefs with the rights of transgender employees. It's been the subject of numerous media stories and employment tribunals, and we want to give you the information that your organization needs to reduce the risk of a compliance breach in this area. Obviously, this is a very sensitive subject. VinciWorks, as well as our partners WorkNest, who are here on the webinar with us, we're not here to take sides. We're not here to advance any sort of particular agenda. Our perspective is what's the law and what's best practice for organizations. And our job is to help your organization reduce the risk of a compliance breach. And we do really want to hear from you during today's webinar. So if you do have any questions or comments or experience of some of these issues, please do let us know in the chat or the Q&A, and we'll try to read out as many of those as we can as we go through. So to get through everything we've got to talk about today, I'm delighted to be joined by Sarah Hennidahan, VinciWorks' regulatory and compliance expert.
Hi, Nick. Great to be here today and so much to talk about.
Great to have you on with us today. And also a very warm welcome to Stuart Watkins, a professional support lawyer from WorkNest. Great to have you with us today, Stuart.
Thanks, Nick. It's great to be here.
And we're really delighted to have Stuart on with us from WorkNest. And WorkNest delivers first-class employment law, HR, health and safety support backed by hands-on consultancy and advanced technology. And they help organizations of all sizes and industries confidently manage their employment, safety and well-being challenges, all accessible via their user-friendly portal, My WorkNest. So if you'd like to hear more from WorkNest, or if you have any particular employment law challenges you would like specific and direct support on with WorkNest, you can write the word WorkNest into the chat box, and we'll make sure the WorkNest is in touch with you after the webinar to talk about your different employment law and HR needs. And if you'd like to see any more VinciWorks' training options around equality and diversity, you can write the word demo into the webinar chat at any point, and we will be in touch with you to chat more about that. And just to let you know about a few of our upcoming webinars you might be interested in, on the 19th of March, so next week, we are doing a webinar on empowering future leaders. On Wednesday, 23rd of April, we're looking at health and safety and the employment rights bill. Then on Wednesday, 14th of March, we're looking at the issues around cultural awareness at work. Then on Wednesday, 28th of May, we are looking at GDPR 7 years on. So the links to those webinars are coming up in the chat now. You're welcome also to pass those on to any colleagues who you think would be interested. And you can also download our guide to the big issues in equality, diversity and inclusion this year and how to prepare for all of that, which is also coming up in the chat. And WorkNest have very, very kindly made available their fantastic protected characteristics guide, and the links we are coming up shortly. We're just having a little issue with the links, unfortunately, so we're going to get to those soon. If we're not able to do that, then we'll email you all the links we're talking about afterwards. So you'll get them one way or the other. Apologies that they haven't come up in the chat yet. If they do, they'll be there. Otherwise, we'll email them to you anyway, or just write into us as well, and we'll get those links to you. So let's get into the subject of today. So Sarah Henna, we're obviously going to get into protected beliefs under the Equality Act, but if you can just start us off with the purpose of the Equality Act and why it's so important for the workplace.
Sure. Thanks, Nick. And hello, everyone. The Equality Act 2010 is one of the most significant pieces of employment legislation in the UK. It was introduced to streamline and consolidate multiple anti-discrimination laws that existed before, making it easier for businesses and individuals to understand their legal rights and obligations. So previously, before that, we had patchwork of laws, including the Sex Discrimination Act 1975, the Race Relations Act 1976, and the Disability Discrimination Act of 1995. And the Equality Act 2010 brought them all together under one legal framework, ensuring that individuals are protected from discrimination across various areas of life, including employment, education, and access to goods and services. The Act also introduced new protections, such as making it easier for individuals to prove indirect discrimination, strengthening the protection for disabled people, and introducing the concept of associative discrimination, meaning that you can't be treated unfairly because of someone else's protected characteristic, such as caring for a disabled relative. So that means that you shouldn't be discriminated against because of your association with someone who has a protected characteristic.
And the Act, it doesn't just protect against obvious discrimination, does it? We also are covering indirect discrimination, which could mean policies or procedures that could be discriminatory.
Yeah, that's exactly right. So alongside the 9 protected characteristics, the Act protects against 4 key types of discrimination. So the first is direct discrimination. That's when someone is treated less favorably because of a protected characteristic. For example, refusing to hire someone because of their age or gender. Then there's indirect discrimination, when a neutral policy or practice applies to everyone but disadvantages certain groups. For example, requiring all employees to work on Saturdays could indirectly discriminate against Jewish employees who observe the Sabbath. Then there's harassment, which is unwanted behavior related to a protected characteristic that violates a person's dignity or creates an intimidating, hostile, degrading, humiliating, or offensive environment. And finally, victimization, which is treating someone unfairly because they have made a complaint or supported a discrimination claim under the Act.
So that's the basics that we all are hopefully familiar with. Tell us about the Act's rules on positive action. So where employers might be able to address inequalities in their workplaces. How does that work under the Act?
Yeah, so positive action allows employers to take proportionate steps to help disadvantaged groups. For example, if a company recognizes that women are underrepresented in senior management, they can implement a leadership development program targeted at female employees. However, this is different from positive discrimination, which is not allowed under UK law. So while businesses can support underrepresented groups, they can't give them preferential treatment over equally qualified candidates in hiring decisions. Hiring decisions must always be based on merit. In general, positive action should be about leveling the playing field, not giving unfair advantages. But there are some areas, such as disability, where it might get a bit more complicated. For instance, leveling the playing field for a disabled person could mean certain reasonable adjustments, which might mean an employer puts in place certain steps which try and remove barriers.
Mm-hmm.
Also, in some circumstances, there may be a genuine occupational requirement to possess a particular protected characteristic.
Fantastic. Thank you very much for taking us through that. Let's just pause here for a moment and ask a poll question of the audience. So the poll that will be popping up in your screen in a moment. Do you think your current equality and diversity training is effective? Yes, very effective. It's okay, could be better. It's not very effective. We don't have equality and diversity training, or not sure. So do you think your equality and diversity training is effective? Yes, very effective. It's okay, could be better. Not very effective. We don't have quality and diversity training, or not sure. So we're going to give everyone just a moment to answer the question, and then we will have a look at the results from that. So we have 20% saying yes, it's very effective. 55% saying it's okay, it could be better. 9% saying it's not very effective. 11% don't have equality and diversity training, and 5% not sure. Very, very interesting results there. Just a reminder, if you'd like to know more about the training options that VinciWorks has available, please do write demo into the chat. And if you'd like to know more about WorkNest employment law solutions, you can write WorkNest into the chat. So let's now talk about why the Equality Act is so important for business. What are the key reasons why we need to take this seriously?
Yeah, so there are 4 main reasons why businesses should actively engage with the Equality Act. The first is legal compliance. Failing to comply with the act could lead to employment tribunal claims, legal costs, and reputational damage. There's also the issue of workplace culture. A workplace that values equality and diversity has been shown to be more productive, innovative, and attractive to talent. Then customer relations, there's that issue as well. Businesses that are inclusive and accessible can serve a wider customer base and build stronger brand loyalty. And finally, I would say reputation and ethics, that ethical businesses that promote equality and diversity do tend to have stronger reputations and higher employee engagement.
Mhm. Fantastic. Well, thank you very much for that. And what about some of the recent updates to equality law that we need to be aware of?
Yeah, absolutely. So one major update is the Worker Protection Act 2023, which came into effect in October 2024. This strengthens protections against sexual harassment in the workplace, and it requires employers to take proactive steps to prevent harassment, to conduct risk assessments, to update policies and procedures, to provide training, and to establish clear reporting mechanisms. And failure to comply could result in increased compensation claims and enforcement actions from the Equality and Human Rights Commission.
And let's just ask the audience about that issue now because it is a recent change, but obviously quite a significant one. So next poll popping up on the screen. How would you rate the sexual harassment training in your workplace? Excellent, good, could be better, not good, or we don't do training. So how would you be rating the sexual harassment training in your workplace? Excellent, good, okay, could be better, not good, or we don't do training. So we're going to give a few moments for everyone to have a chance to answer that poll. Obviously, that is something it's a new requirement through the Worker Protection Act to take obviously reasonable steps to prevent sexual harassment. So a new requirement on us to think about. Training obviously can be one of those reasonable procedures, but how effective is that? That's always a key question. So let's have a look at the answers once everyone's had a chance to vote. 17% saying it's excellent, which is great to see. 27% good. 26% could be better. 9% not good. And 21% don't do sexual harassment training. Very, very interesting results there. Sarah Hannah, what do you make of those?
They are interesting, and I'll just say that sexual harassment is not an easy subject to train on effectively. It's always an uncomfortable and sensitive subject, but as opposed to an overly legalistic tick box exercise, we do want this kind of training to engage people and to make them think. So there's certainly a lot more work for organizations to do on sexual harassment because of the Worker Protection Act. We have a link to our guide to your obligations under the Worker Protection Act coming up in the chat now, which you can download, which hopefully will be a helpful start.
Fantastic. Thank you very, very much for that. And obviously, if you'd like to see more about our sexual harassment training for the Worker Protection Act, you can write WPA into the chat specifically to try that particular course. Thank you for taking us through the summary of that and let us all get onto the same page around the Equality Act and the updates to that. Now we obviously want to get into the specific issue for today, which is protected beliefs, specifically how they interact with other workplace rights, such as those of transgender employees, and how employers can navigate this very sensitive and often legally complex issue around protected beliefs. So we're going to bring in our special guest from WorkNest, Stuart Watkins, very shortly to go through that in detail. But Sarah, just give us a very brief overview of protected belief.
Certainly. So under the Equality Act 2010, belief is defined quite broadly. It covers both religious beliefs such as Christianity, Islam, Hinduism, and philosophical beliefs, which can be non-religious but still deeply held. For a philosophical belief to be protected, it must meet a specific test set out in a case called Granger PLC versus Nicholson. And I know Stuart is going to cover that in some more detail for us shortly.
That's really helpful. Thank you. So, for example, we know things like ethical veganism have been ruled to be a protected belief, but then something like English nationalism with anti-Muslim and anti-immigration influence has not been a protected belief. But you mentioned earlier the real challenge, obviously, is for employers to balance where there might be competing rights, whatever the opinions or issues at play it might be. And one of the most high profile areas of conflict around protected beliefs we've seen recently is between employees who hold gender critical beliefs and those who might identify as transgender.
Yeah, this has been one of the most litigated and debated topics in employment law in recent years. In essence, some employees hold gender critical beliefs, meaning they believe that biological sex is immutable and cannot be changed. Others, particularly transgender employees, hold the opposing view that gender identity should be recognized and respected regardless of biological sex. The legal challenge for employees is balancing these rights in a way that complies with the Equality Act while also preventing harassment, discrimination, or workplace conflict. Now, Stuart is an expert in this area and will take us through the detail of the law. But from a business perspective, whenever these things come up in your workplace, there are 5 key points that employers should keep in mind. So the first is to avoid knee-jerk reactions. So don't immediately suspend or dismiss an employee just because their views may be controversial. Next is to consider the context. So was the expression of belief inappropriate or just offensive to some? Then distinguish between belief and conduct. So holding a belief and expressing it in a way where objection could not reasonably be taken is protected, but harassment would not be. Then it's important to assess reputational risk properly. You need clear evidence of harm and not just fear of negative attention. And finally, be consistent. If you allow some employees to express strong beliefs, then you're going to have to apply the same standards to others.
Very, very good advice there. Thank you very much. And just let's ask one more poll before we get into to bring in Stuart Watkins in a moment. Do you have a policy around protected belief in the workplace? Yes, and it's regularly updated. Yes, but it's outdated. No, but we're looking to develop one. No plans to have a policy, or not sure. So, do you have a specific policy around the issue of protected belief in the workplace, or even a section in the policy? Yes, and it's regularly updated. Yes, but it's outdated. No, but we're looking to develop one. No plans to have a policy, or not sure. And we'll give everyone a little moment to answer that poll question, and then we'll see what people think about that. Okay, interesting spread of results there. 16% have a policy around protected belief and it's regularly updated. 12% have, but it's outdated. 22% are looking to develop one. 26% no plans to have a policy. 24% not sure. Very, very interesting to see about that, the issue of a specific protected belief policy. And just a reminder, if you would like to know more about the different training options on equality, diversity, and compliance that VinciWorks has available, you can write demo into the chat and we'll be in touch with you about that. Or if you'd like to know about WorkNest employment law solutions, please write WorkNest into the chat. And we also have a couple of great downloads for you coming up in the chat now. We have our 2025 inclusion calendar with all the dates and everything that you need to know, major holidays and celebrations. And another great download from WorkNest, who've made that available for this webinar very, very kindly, which is their guide to inclusive language in the workplace. So 2 great downloads to get there with the links coming up in the chat. If you can't access those links for any reason, let us know and we'll get a different way to get that for you. Okay, so let's introduce now our special guest, Stuart Watkins, who is a professional support lawyer with WorkNest. And as we said, WorkNest delivers first-class employment law, HR, and health and safety support, backed by hands-on consultancy and advanced technology. And if you would like to know more about WorkNest, type that in and we'll make sure that WorkNest is in touch with you after. Very, very warm welcome to you, Stuart. Great to have you with us. So, how long have you been working in employment law for?
Well, thanks again for having me on. So I've been practicing employment law for about 20 years. Initially started with acting on behalf of both employers and employees in employment tribunal matters. I've been working with WorkNest for about 14 years, advising and representing employers. Now I work primarily as a professional support lawyer, and that involves me providing support and training to the advisors within WorkNest, and that includes solicitors, barristers, and HR professionals, as well as providing some client training as well.
So, you've really seen a lot of what's going on in employment law in the last little while. What are some of the key employment law trends you've been seeing over the last few years?
It's definitely got busier in terms of employment law. Aside from the topic we're going to be talking about today, which has seen a lot of case law and publicity, we've also got the Employment Rights Bill, which is currently working its way through Parliament, and that's going to involve some significant changes in employment law if it comes in. I think another area of interest is around collective and trade union rights, and that includes how human rights play their part in that area, which is something that's common in the topic we're talking about today. But that collective bargaining and trade union rights has seen a lot of action in the Supreme Court in recent years as well. So that's another area to keep an eye on.
Really, really interesting things happening in that field, absolutely. And how far can some of these human rights cases go in changing the actual letter of the law? Could it be like a fundamental change that a human rights case could bring, or is it more like tinkering around the edges of things?
I think it depends really. The starting point is the European Convention of Human Rights, and that contains a number of rights, including, for example, the right to respect for private and family life, freedom of assembly and association, which ties in with the trade union cases, and freedom of thought, conscience, and religion and expression as well, which is relevant for today. And that can have an impact on the employment relationship. While generally speaking, it's not possible to directly enforce the European Convention against employers, except where there is the public authority, a public authority is the employer. Under the Human Rights Act, courts and tribunals are required to interpret domestic legislation as far as possible without going against the grain of that legislation to protect those rights under the Convention. So that's where we've seen the cases around collective bargaining rights and also around freedom to hold and express certain beliefs. And that's how it sort of ties in there.
Very, very interesting. Thank you for that. And obviously, the issue of belief is something we're seeing a lot about at the moment. Could you give us a bit of detail about what counts as a protected belief under the Equality Act?
So yes, absolutely. So as has been mentioned before, the Equality Act is the starting point, and that provides protection against discrimination on grounds of various protected characteristics. And one of those is religion or belief. And in the Equality Act, a religion means any religion, and a reference to religion includes a reference to a lack of religion. And belief means any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. So if a worker possesses either or both of those, they're going to be protected from all those forms of discrimination we mentioned before. That includes direct, indirect, harassment, and victimization. I think what a religion is, or what a belief that is connected to the religion is, that largely speaks for itself, although it goes further than simply a belief about adherence to a religion or its central articles of faith. And the belief can vary from person to person too. Philosophical belief, I think, is slightly harder to pin down. And we've got the case of Granger and Nicholson to help us with the requirements for such a belief.
So tell us a little bit more about that case, because that was really interesting, because it set down criteria for what belief is supposed to be. How does that work in practice? What is it? What is the Granger kind of details of that?
Sure. So this case concerned an individual who argued that they had been discriminated against because of his belief in man-made climate change. So clearly not a religious belief. So you're looking at whether or not this is a protected philosophical belief. And this went to the Employment Appeal Tribunal, and they set out a 5-stage test that has to be satisfied in order for a belief to amount to a philosophical belief under the Equality Act. So the first step is that the belief must be genuinely held. And in essence, what this means is it's necessary to establish that the belief is genuine. Also, it must be a belief and not an opinion or viewpoint based on the present state of information available. And we've got one case that said it's not enough to have an opinion based on some real or perceived logic or based on information or lack of information available. Also, it must be a belief as to a weighty and substantial aspect of human life and behavior, and this is relevant in what are often called lifestyle choice beliefs. Also must attain a certain level of cogency, seriousness, cohesion, and importance, and the level of cogency required will be similar to that of a religious belief. And finally, it must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. And there's been quite a few cases on this quite recently, and it sets the bar quite low as to what is worthy of respect in a democratic society. And the cases say that a belief similar to that of totalitarianism or Nazism would not be deemed to be acceptable. But anything sort of above that probably will be. I think one other important point is that it's important to remember that a lack of religious or philosophical belief is also protective, and that doesn't necessarily need to be assessed using that criteria that I've just gone through.
That is really, really interesting to know. Also, I know we just had a question from the audience about who defines what a belief is, and I guess that is really where the definition can come from. An employment tribunal would assess something with those criteria to then make a decision about whether something is a belief or is a protected belief or isn't a protected belief. So what kind of beliefs have been found to be protected, and what kind of beliefs have an employment tribunal looked at and said, no, this is not protected? Can you take it? I don't know if you're still with us. Stuart might have had a little issue with Stuart's sound and video. So let's just have a look at some of the beliefs that are up there on the screen. And we've had an interesting range of beliefs that have been. Oh, Stuart, are you back with us?
I'm back with you now. Yeah,
Great,
I lost you for a
fantastic.
second. Apologies.
Oh no, I was just about to do your part really, which is to look at what's coming up on the screen.
Sure.
So take us through some of the beliefs that have been found to be protected, and then also ones that have not been protected.
Yeah, so the types of beliefs that have been found by an employment tribunal to be capable of being protected philosophical beliefs include gender critical beliefs, which we're going to talk about further, a belief in the sanctity of life extending to a fervent anti-fox hunting and anti-hare coursing belief that constituted a protected philosophical belief. A belief in the higher purpose of public service broadcasting is an interesting one, I think. That was a case against the BBC. Ethical veganism has been found capable of being a protected belief. Scottish independence, anti-Zionism as well was one that was found to be a protected belief in the circumstances of that case, and also a belief in Stoicism as well. So as you can see, it's pretty broad, the types of things that could fall within a protected belief. In terms of those that are found not to be protected, a recent case found that a belief in English nationalism with an anti-Muslim and anti-immigration aspect wasn't protected. Holocaust denial also wasn't protected. Wearing a poppy in November, a belief in that wasn't found to be a protected philosophical belief. And also another interesting one is supporting a football club wasn't a protected belief either.
Really, really interesting set of beliefs. And I guess it's something that's always changing, isn't it? With every new employment tribunal, there could be something new that might be found to be protected or not protected. So let's I'll just pause there for a moment to ask another poll question of the audience. Sarah Hannah, take us through the next question, please.
Sure. So our next question for today is about workplace conflict. And the question is, how concerned are you about a protected belief conflict in your workplace? And the options are very concerned, fairly concerned, somewhat concerned, not concerned, or not sure. I'll repeat the question. How concerned are you about a protected belief conflict in your workplace? very concerned, fairly concerned, somewhat concerned, not concerned, or not sure. And we'll just give everyone another moment to send in their answers, and then we'll see what the results of this poll are. Okay, so we have our results. So 14% of you said that you're very concerned, 18% said fairly concerned, 31% said somewhat concerned, 33% said not concerned, and 5% said not sure. So there's some very interesting results there. Again, just a reminder, if you'd like to know more about the training options that VinciWorks has available, please do write demo in the chat. And if you'd like to know more about WorkNest's employment law solutions, please write WorkNest into the chat.
Thank you very much for taking us to that poll question. Very interesting set of results there. Absolutely. So let's, Stuart, look at the kinds of issues that might arise then regarding this world of religion and philosophical belief. What's the problems really that might come from that?
So all the usual forms of discrimination are covered for religion or belief discrimination. So we've gone through them. Just as a reminder, that's direct discrimination, indirect discrimination, harassment, and victimization. I think the important thing to remember is that if someone is singled out and either treated less favorably or dismissed simply because they hold a protected belief, that's going to amount to direct discrimination, and that can't be justified. There are some very limited circumstances where this could be allowed if there is a genuine occupational requirement for someone to be a member of a particular religion or hold a particular belief. That's pretty rare.
Mm-hmm.
Some of the other common issues that tend to arise around protected religion or belief discrimination include dress codes. So if dress code is implemented by an employer, that could potentially amount to indirect discrimination if it adversely affects someone who holds particular religious beliefs. We've got the Equality and Human Rights Commission, and they've got a code on this, and they give a couple of examples, which are quite helpful. So for one is hairdressers refusing to employ stylists who cover their hair. They may place Muslim women or Sikh men at a disadvantage if they cover their hair because of their religious beliefs. A no jewelry policy as well is another example, and that might place Sikh workers who wear a Kara bracelet or a Christian wearing a cross or crucifix because this is an integral part of their religion. That might place them at a disadvantage compared to others who don't hold such beliefs. I think with indirect discrimination, it is possible for an employer to try and justify the policy by saying that it is a proportionate means of achieving a legitimate aim. Similarly, as well, we've got around time off for prayers and religious holidays. If someone is placed at a disadvantage because they're unable to take those holidays because of a particular neutral policy that's in place, that could be indirect discrimination as well. But again, that can potentially be justified. I think the area that's probably seen the most case law and press attention recently is around expressions of belief, both in and outside of work. And this can be a particular issue if the expression of belief potentially conflicts with someone else's protected characteristic, for example, sexual orientation or gender reassignment.
Absolutely. And that's obviously the complex area that we're going to give a bit more attention to now. Obviously, gender reassignment is a protected characteristic under the Equality Act. Protected beliefs are also protected. And regarding that example, we've seen some quite high profile cases obviously talked a lot about. We've got For Starter versus CGD Europe, and then the Alison Bailey and Stonewall case. What were the different legal principles that these cases established?
Well, For Starter and CGD Europe, I think that was one of the first cases to consider the issue of whether what are referred to as gender critical beliefs can be protected beliefs under the Equality Act. And there, the Employment Appeal Tribunal the Employment Appeal Tribunal found that such beliefs could be protected. The claimant in that case expressed gender critical beliefs on social media to a large audience, and her employer did not renew a contract following receipt of a number of complaints stating that the views were transphobic. And the employer argued that the reason for not renewing her contract was because of the manner in which she expressed her opinions, which would, in their view, cause reputational damage. However, the employment tribunal in that case found that the non-renewal of the contract amounted to direct discrimination, since the manner in which she expressed her views could not be considered to be objectionable and, in effect, just stated or reflected what her beliefs were. Therefore, the reason for the treatment was found to be the belief itself. Other factors that were taken into account by the tribunal were that the claimant had offered to ensure that any social media profiles clearly stated that the views were her own, and that she would anyone in the workplace. Therefore, in the employment tribunal's view, the risk of damage to the employer or harassment of other colleagues was minimised. There's since been a raft of cases around this particular issue around expression of gender critical beliefs, and Bailey and Garda Court Chambers is another example. And there, very briefly, the claimant expressed gender critical views online. That included opposing the involvement of trans rights and charity in the employer, and that led to a lot of complaints being made to the employer, both internally and externally. And the employer investigated, took disciplinary action, and also issued a public statement regarding the investigation in order to try and temper what they perceived to be an online backlash. And that in itself was found to be an act of harassment because of her protected philosophical belief. And again, the action taken by the employer was found to amount to direct discrimination, since her beliefs were protected and she was entitled to express them in the way that she did. There were also, there've been a lot of other tribunal cases which are found in favour of claimants on similar grounds.
So has there been any cases, though, maybe where an employer has successfully defended claims where exception has been taken to what was said or done, or the manner to which it was expressed?
Not quite as many, but there have been a few. One that's I think is worth mentioning is Orwin and East Riding of Yorkshire Council. And in that case, the employee objected to the introduction of a pronoun policy by the council on the basis that it promoted, in his view, a political ideology of self-identification which conflicted with his gender-critical beliefs. He expressed his objection by using a provocative email signature, which could be seen both internally and by external recipients. The council discussed the matter with the employee, trying to understand his position, as well as explaining to him the problems with having such a signature and the impact this could have on those trying to access the services within the council. And they tried to see if there was another way he could express his views in a less provocative way. And he refused to remove the signature despite requests to do so, and he was subsequently dismissed. And the tribunal rejected his claims that he'd been discriminated against because of his protected beliefs. And the approach taken by the council was, in these circumstances, a proportionate response to what the tribunal said was an inappropriate expression or manifestation of his beliefs. Relevant factors included the fact that he had a public-facing role and was using the council's email to be intentionally provocative. And there was a much higher risk in the tribunal's view of reputational damage than had he just expressed those views on social media, for example.
Yeah.
Another example is McCarrath and the Department for Work and Pensions. And there the employee was a disability benefits assessor and had to carry out in-person health assessments on occasion. He refused to use preferred pronouns of transgender benefit claimants, and there were numerous meetings that took place between the parties where the employer explained why it was necessary to use preferred pronouns, particularly the fact that such people using the service may be suffering from issues which could be exacerbated by the employee not using the preferred pronouns. The employee resigned at that point, claiming that he had been discriminated against. The employment tribunal disagreed. They made the point that he hadn't been suspended or put under any pressure to denounce his beliefs, Importantly, in this case, the employee had resigned before further alternative options could have been properly explored, although there may have been an argument potentially that such a role would have required preferred pronouns to be used on occasion, and if they could not, alternative positions could have been considered. I think one important point regarding all these cases I've just mentioned is that they are tribunal cases. So they're very helpful, I think, in illustrating how a tribunal approaches these types of issues, but they're not binding on other courts or tribunals, which means they don't have to be followed.
That's a very interesting point, that this is not necessarily putting down precedent, but maybe giving us guidance on how we might deal with some of these issues. Let's take a very brief break here for another poll question. Sarah Hannah, what do we have next to ask the audience?
Thanks, Nick. Yeah, so the next question we want to ask is, how confident are you that your organization can effectively manage conflicts related to protected beliefs? Very confident, somewhat confident, not very confident, not confident at all, or not sure. I'll repeat that one more time. How confident are you that your organization can effectively manage conflicts related to protected beliefs? Very confident, somewhat confident, not very confident, not confident at all, or not sure. And in a moment, we will see the results of this. Okay, so 13% of you said you are very confident. 57% said that you are somewhat confident. 21% said not very confident. 6% said not confident at all, and 2% said they're not sure. So it's interesting results there. It's good to see that there are a good number of people that do feel very or somewhat confident, and there's also you know around 21% that said there's still work to be done. And just a reminder, if you would like to know more about the training options VinciWorks has, please do write demo into the chat. And if you'd like to know more about WorkNest employment law solutions, please write WorkNest into the chat. We also have another great guide from WorkNest to share here, and that is employment law considerations around LGBTQ+ staff. So the link for that is coming up in the chat right now, and feel free to download that one as well.
Thank you very, very much, and very interesting results there. Like you said, great to see a lot of confidence, or a reasonable amount of confidence in dealing with some of these issues. So we talked just there before about the fact that these tribunal cases are not necessarily binding, but do we have any higher court decisions that maybe give us a bit more kind of, I don't know, rules or kind of ways to help us navigate this area?
Yeah, well, very helpfully and somewhat fortuitously, I think we've had a very recent Court of Appeal decision in February of 2025, and this was Higgs and Farmers School. So this is now the leading authority regarding this particular issue, and this is another case where the employee expressed views on social media regarding objections to gender fluidity and same-sex marriages being taught in schools. And she did this by reposting someone else's posts on social media. And a parent of one of the pupils in the school in which the employee worked complained, voicing concern that she could influence decisions within the school based on the views that she expressed, and also place vulnerable students at risk. And the employee denied that this would happen. After investigating the matter, the school dismissed her, primarily because they were concerned about reputational damage in the future, as they believed others would think that she held homophobic and transphobic views based on the information she had reposted on social media. The Court of Appeal placed a lot of weight on the fact that the European Convention of Human Rights I mentioned earlier contains fundamental rights regarding freedom of religion and expression, which also includes the right to manifest or express those beliefs. And the expression of protected beliefs can be restricted, but only where it's proportionate to do so, when bearing in mind the rights of others as well. Therefore, any action taken by an employer in response to a manifestation or expression of belief will have to be proportionate. The court found in this particular case that dismissing the employee was not proportionate for a number of reasons. The first one was that even if the language in the post that she had reposted passed what could be considered the threshold of objectionability, it wasn't, in their view, grossly offensive. Also, the language used by the employee was predominantly not her own, and she had made clear that while she agreed with the general message being conveyed, she didn't agree with the language being used. While this is not a get out of jail free card for employees, it is a relevant consideration. Importantly, in this case, there was no evidence of reputational damage being caused. There was only one person who had identified her on social media as working at the school by the time the employer had decided to dismiss her. And there was no reason not to believe the employee's assertion that she would not bring this into the school or treat anyone differently because of her beliefs.
So really, really fascinating judgment, and obviously kind of gives us a bit more kind of detail on particularly that area around reputational damage and whether is that risk or is that real, and those different kind of, I guess, guidelines for what we should be thinking about when these sorts of issues might come up. Now, did the Court of Appeal set out any specific guidance for employers on how they might deal if something is a problematic expression of belief? Obviously, this one was found to be not to be problematic, but if it was, what kind of ways should we deal with that?
Sure. Well, thankfully, they did give some guidance. Firstly, the employer should establish whether the belief is protected and also whether the expression is sufficiently connected to the belief in question. Because if there isn't that connection between the expression and the belief itself, then it's not going to be a protected expression.
Mm-hmm.
The other important factor and their guidance is that the employer should consider whether the expression was, objectively speaking, inappropriate. And it's important to remember again that the right to hold and express beliefs are fundamental human rights. So just because an expression causes offence does not necessarily mean that it's inappropriate. On this, they provided some more general guidance on the types of things employers might look at when considering whether an expression is objectionable. They were at pains just to sort of say, though, that this is just, suggestions. Don't stick rigidly to it, but I do think that they are quite helpful in sort of giving a bit of a steer on the types of things to look out for. And it includes such things as what's contained in the expression, the extent of the manifestation, what's the worker's understanding of the likely audience, any consequential impact on the employer's ability to run its business, and other things as well. The nature of the employer's business is particularly important. The other things that are worth noting is that even if the employer can legitimately take objection to the expression of belief, any action has to be proportionate, and that's going to include balancing the rights of others, considering what your aim is and whether there's a less intrusive measure that could be implemented to achieve it. So just a very simple example is that instead of dismissing or disciplining, could training or mediation achieve the same ends?
Yeah.
The other things as well, just to sort of bear in mind, there was a warning from the courts for employers who apply stereotypical assumptions to those who hold these or in fact any protected belief. So just as an example, in this case, if an employer were to make a decision to discipline or dismiss an employee who expressed gender critical beliefs because they believe someone who holds those beliefs is transphobic, the reason for any treatment may well be treated as being because of the belief rather than the expression itself. So you need to be very careful with stereotyping. And finally, just on reputational damage, if you are going to rely on reputational damage or you're concerned about reputational damage, make sure you've got clear evidence to support that.
That is a really, really good summary and very, very vital, I think, for us to remember. And just a reminder, this will be shared, obviously, the recording afterwards. So you're very welcome to also share this recording with people in your organization as well. So that was a great summary, obviously, a very critical case for us in this area. What kind of, I don't know, general lessons, what kind of takeaways from these cases we've seen so far can we maybe take back into our workplaces?
Yeah, so in addition to the what I've said around the Higgs case and what the Court of Appeal said, I think the key point is to ensure that you do not take knee-jerk reactions. Take a step back and actually see what's happened. In the cases that have been successful for claimants, I think generally speaking, it seems as though the employer has decided what they think they should do before they've properly investigated the matter. And I think potentially as well, they've allowed their own views on the belief in question to influence their decisions. Of course, there may well be others, there may be situations where you have to act quickly. For example, where it's quite clear that harassment has or is occurring and there's a risk or safety issues for particular individuals. However, it's important to remember that even suspending someone can amount to an act of discrimination and can be less favourable treatment. It's also going to be important to approach the matter objectively and sensitively. The cases where the employers have been successful in defending the claims have attempted to go through a sensitive investigation, recognising the fact that the right to hold such beliefs is a fundamental human right in law. Also, if you're going to take action, it's necessary to consider whether that is proportionate when taking into account the facts of the matter.
And what about maybe some policies or kind of concrete steps that maybe we can put in place before something might happen? What kind of things might we do in that area?
Sure. Well, I think a lot is going to depend on the nature and risk profile of the organisation itself. But I think at the very least, there should be clear policies on harassment so that the workforce know what type of behaviour is unacceptable. This should already really be in place in respect of sexual harassment anyway, just given the recently introduced provisions that was mentioned right at the beginning. But making clear that harassment on any protected ground, including beliefs, sexual orientation and gender reassignment, will not be tolerated. That's going to go some way to help. If you're going to introduce further policies as well, for example, a pronoun policy, I think it's advisable to make this voluntary and consider how to implement this as well, bearing in mind that there may be some people who don't agree with it. Other practical steps might include implementing regular training to ensure everyone understands what is expected of them in terms of behaviours. Instilling a culture of dignity and respect in the workforce, and that can be done again via training and policies. One point you might want to look at is social media policies and reviewing those. I think it's going to be really difficult to control what someone says in their private life. Employers could ask employees to make sure that they state views of their own, and also just remind them to use respectful language, bearing in mind anyone can read this stuff now. Just bear in mind how it might impact others as well. One important element from these cases is if an employer is going to make any sort of statement, whether internally or even more importantly externally, be careful what you say. A number of the cases involved employers making public statements implicitly criticising the employee for their views, and that was found to amount to harassment and discrimination as well. And finally, as well, remember that while the employer needs to ensure that they do not discriminate against someone for holding protected beliefs, there may be legal requirements the employer has to adhere to if they are a service provider, which could justify action being taken in certain circumstances. So an example of this is one case that it was not discriminatory for a charity to dismiss a Christian relationship counsellor who said they could not provide counselling to same-sex couples because of their religion.
That is a really, really helpful summary and really great practical steps that we can take away. We have been through obviously what the law is. We've been through what happens if an employee claims discrimination based on their belief or their lack of a belief. If an employer worker is successful in their discrimination case, what can happen next? What kind of awards or kind of compensation can they expect?
Yeah, so discrimination claims, the common awards generally include loss of earnings, and that's pretty much what it says on the tin. It's to reflect the loss incurred by the claimants in terms of their earnings. There's no limit on this in discrimination claims like there is in normal unfair dismissal claims. So that could get pretty expensive if someone's out of work for a long time. It can also include other financial losses, including pensions and other benefits. If they are dismissed, they're going to may be entitled to what's called a basic award. And that's calculated probably in the same way as a statutory redundancy payment. The big one normally is around injury to feelings. And this is to reflect the injury they've sustained because of the discrimination itself. And this is calculated using what's called the Vento scale. And how much this is will depend on the extent and nature of the discrimination. Just as an example, Maya Borstatter was awarded £25,000 in injury to feelings, and there was also an additional £2,000 awarded for aggravated damages because of the public statements made on behalf of the employer following the judgment being issued. So those are quite big awards. In addition, if someone has actually suffered personal injury, whether physical or mental, because of the discriminatory treatment, that could also be claimed. Again, what's awarded depends on the nature and extent of the injury. I think also just one other consideration is that if there's a failure to follow an applicable ACAS code of practice, for example, a code of practice on disciplinary and grievance procedures, an uplift to that compensation could be applied.
Fantastic. Thank you for taking us through that. I know we're just about to come up to the hour. We do still have a few questions that have come in that we really want to get to. So if you do need to leave us now, you're very welcome to. Obviously, thank you so much for coming along. You will receive a recording afterwards, and the recording will include the next kind of maybe 5 minutes. We'll be able to stay on. If you are able to stay on with us for another 5 minutes or so, then we'll just go through some more of these questions that have come in because we really want to give as much of kind of as we can around this. And Stuart has a really vast wealth of knowledge here that we want to take as much as we can before the end of the webinar. So if you are able to stay with us for another 5 minutes or so, we will just go through the rest of some of these questions that have come in. So Stuart, if a business is facing a tribunal case on a protected belief, hopefully that wouldn't happen, and the steps you've outlined can prevent that. But if it comes to a tribunal case, what kind of steps should a business do next?
So these types of cases, the first thing I would do is seek legal advice. I think actually seeking legal advice, perhaps at an earlier stage, might be quite helpful. These are, as perhaps has become apparent from sort of going through this talk, they are complicated and they're very fact specific. I think also just because of the nature of the issues that can arise here, I think it might be advisable in some situations to consider public relations advice, since these types of claims can and have attracted quite a lot of public and media attention. I think other than that, if you are faced with a tribunal claim on this, I think start to collect any relevant documentation and consider who may be relevant to call as a witness. Also consider whether or not settlement is a realistic prospect. These claims are notoriously, I think, unpredictable, and it is an evolving area as well. So that is something just to bear in mind. I think finally as well, it may be that mediation, even after the claim has been issued, is an option. And it might be possible to enter into judicial mediation as well if there is a claim ongoing.
And is there maybe any other big cases like the ones we're just looking at, or any other significant rulings that maybe we're expecting to see soon?
So on this particular issue, there are a couple of EAT or Employment Appeal Tribunal cases that may be influenced by the recent Court of Appeal decision. So it's going to be interesting to see how the principles set down in that case are applied going forward. I think also the Bailey case I mentioned before, I believe that's going to the Court of Appeal, but on a slightly different issue around how third parties can be held to have caused or induced discriminatory acts of an employer. I think just finally as well, I've not heard anything around whether the Higgs case is getting appealed. So that could potentially go to the Supreme Court, but I've not heard anything on that just yet. But it's definitely a watch this space at the moment.
Definitely feels like it, absolutely. Great summary there. Some of the other questions we've had in, would love to get your thoughts on. One question we had in, I think it really sums up a lot of this, doesn't it? How do we manage freedom of expression or against or versus or with protection from harassment? How do we balance those things?
Yes, so I think the right to manifest a protected belief doesn't give the green light to someone to harass someone, because of a reason connected to a protected characteristic. So an example in the context of the cases above might be that someone who holds and expresses gender critical beliefs can't just intentionally misgender someone who has the protected characteristic of gender reassignment. That may amount to harassment under the Equality Act, and may be relevant to a couple of the questions that arise in these cases. Firstly, is that expression actually protected at all? And if so, whether any subsequent action taken against that individual is proportionate, which will be dependent on what comes out of any investigation.
Very, very interesting for us to think about that, the balance there. And next question we had in, how do we ensure that all employees feel respected at work when views about diversity and identity can be a source of tension?
I'm not going to pretend this is easy. I hope that's sort of come across, but it is tricky. I think the points that come to mind are ensuring that everyone understands what behaviour is expected of them, particularly on the point of ensuring that people know what harassment is and not to do it, basically. I think we're also reminding people to be understanding and tolerant of each other's beliefs and circumstances, but also remembering that your actions can affect others. So think about how your actions may be perceived by others. One phrase I've seen or heard recently was trying to sort of encourage people to disagree agreeably, which I think sort of maybe simplifies this particular issue to a good degree, but it's not a bad phrase just to have in the back of your mind, I think.
Absolutely. And then the very last question for today, maybe a bit of a crystal ball one, but will the changes to DEI, so diversity, equality, and inclusion in the US, have a knock-on impact in the UK?
Well, I think this is largely going to depend on the influence of the US arm of the business has on any UK-based operations. I think the most important thing to remember, though, is employers in the UK are subject to the wide protections regarding discrimination, and these are likely to become more extensive rather than scale back under the current Labour government. So it's going to be really important to ensure that they are complied with where that jurisdiction applies.
Yeah.
Unless you want to face expensive, time-consuming tribunal claims, and also potentially the public attention that these cases appear to get.
Absolutely. Well, thank you very, very much for taking us through that. Thank you for everyone who stayed on for the last 5 minutes there just to get through your questions. That's really all the time we have for today. Thank you so much to our panelist, Stuart Watkins from WorkNest, and from Sarah Hannah Dahan. Also, thank you everyone who came along today. Remember, you can listen again to this. Also, we're all on Spotify, all of our webinars. Thank you once again to Stuart for the time to take us through all of really, really important subject for us. Thank you everyone that came along today, and we really look forward to seeing you again next time on a VinciWorks webinar. Bye for now.